This is Michael Popak with a Legal AF Hot Take. We got a new order from Judge Juan Merchan, who presides over the first criminal trial against Donald Trump that starts on March 25. We've got a lot of the short game going on right now with filings fast and furious by the Manhattan DA's office in the Stormy Daniels hush money business record fraud case against Donald Trump and Donald Trump alone. 34 counts in particular, business record fraud and conspiracies around it. And now the judge has decided that there needs to be an anonymous jury to protect the jury from future potential tampering of the jury by Donald Trump. And the judge used Donald Trump's lawyers and Donald Trump's own words against him in the order that we just got. And I'm going to break it down for you right here. One place, MeidasTouch, on this hot take. So in the order, what we call in New York a decision in order, a D&O on the motion for protective order, what the government or the prosecutor, the Manhattan DA, was trying to obtain and did obtain is anonymity and protection of the jury. Now, that's already been found to be an appropriate thing in a number of cases involving Donald Trump. The federal judge in the E. Jean Carroll rape and defamation punitive damage case twice ruled that there needed to be an anonymous jury, Judge Kaplan, to protect the jury and the future jury from attacks, doxing, based on Donald Trump and the people around him, his bad behavior. That judge noted that Donald Trump frequently attacks jurors, grand jurors, special purpose grand jurors, jury for people, judges, staff, prosecutors, FBI agents, investigators, and the like. And he made that jury anonymous. He anonymized the jury twice. But the judge in Georgia did the same thing, Judge Scott McAfee, in a little reported decision over about a year ago. He found that the Georgia jury for the future trial of Donald Trump needed to be anonymous as well. And Judge Chutkin in the DC election interference case has considered making the jury anonymous. But now we got Judge Merchan, who's presiding over the first case against Donald Trump, first to indict, first to try, the Manhattan DA's office. And this is what is in the order. Listen to these words. The judge says in outlining on page 1 that the defendant, that's what he calls Donald Trump, not the former president, not anything but defendant, is charged with 34 counts of falsifying business records in the first degree. The charges arise from the allegations that defendant attempted to conceal an illegal scheme to influence the 2016 presidential election. Specifically, the people, that's the people of the state of New York, claim that defendant directed an attorney who worked for his company, that's Michael Cohen, to pay $130,000 to an adult film actress, that's Stormy Daniels, shortly before the election to prevent her from publicizing an alleged sexual encounter with defendant Trump, and then reimbursed the attorney, Michael Cohen, that's my commentary, for the payments through a series of checks and caused business records associated with the repayment to be falsified to conceal his criminal conduct. It's a pretty good and pithy recitation of the charges against the defendant, Donald Trump. The motion here asks to have and to prohibit the disclosure to the public of the jurors' names and their business and residential addresses. The names would go, and that information would go to the lawyers, to the counsel, not Donald Trump, but not there. Now, interestingly enough, Donald Trump's own lawyers felt that that was an appropriate protection of the jurors. Think about that. Just as they did in the E. Jean Carroll case. The lawyers for Donald Trump here believe that the jury needs protection from Donald Trump and people around him and conceded the point. The judge goes on page 1 to say, defendant Trump filed a response in which he consents to the people's first two requests, subject to certain modifications. Specifically, as the judge noted on page 1, defendant Trump indicates that he believes that protective measures against the jury or for the jury are appropriate. Judge, of course, agreed. What the judge went on to say in his discussion section is the bombshell. Here in footnote 1 on page 2, the judge said that there are appropriate grounds and compelling grounds to anonymize the jury and to protect the jury and the disclosure of their names to be limited to the counsel and to consultants of the respective parties, but not the parties themselves, not Donald Trump himself. Here's what the judge said. For example, the people demonstrate that defendant has an extensive history of publicly and repeatedly attacking trial jurors and grand jurors. The motions, affirmations, and exhibits of the respective parties are incorporated herein by reference. Even more so, listen to this finding. The judge says on page 2 that having considered the arguments advanced by the people, including the ones I just told you about the attacks, the virulent vitriol brought by Donald Trump against jurors and grand jurors, the judge goes on, Judge Merchan goes on here to say that having considered the arguments advanced by the people in their motion and the defendants in their response, the court concurs that a protective order to protect the jury is necessary. The court further finds good cause on the record before it that, quote, that there is a likelihood of bribery, jury tampering, or a physical injury or harassment of jurors. Think about that. Donald Trump can't even be trusted to be a criminal defendant in a case without having a jury to be protected from, and the judge doesn't say which one, physical injury. Physical injury to a jury is a possibility in the judge's mind in a trial involving Donald Trump as a defendant. Harassment of the jury, certainly. And a likelihood of bribery. The judge could have used ellipses to put ... I don't think it's the bribery part or the physical injury part, but the harassment part. No, the judge quoted the entire section of the criminal code, including the one about jury tampering and bribery connected to Donald Trump. I mean, just to show you how Donald Trump is perceived outside of MAGA world, MAGA-landia, in the criminal justice system, including by judges, state and federal. This is now the 5th time that a jury's been anonymized and protected from one Donald Trump because of harassment, threat of physical injury, and bribery. The court goes on to use Donald Trump's own words against him. As to the third request, the court says on page 3 over to 4, this court will rule on the people's third request about gagging, effectively a gag order against Donald Trump. And what the court does instead is to recite a series of instructions and acknowledgments, instructions that he gave to Donald Trump's lawyer at the time, Todd Blanche, and acknowledgments not only by Blanche, but by Donald Trump himself, that he understood the rules of the road in that courtroom. The judge says, in particularly on page 3, at defendant's own arraignment on April 4th, 2023. Have I already mentioned that I love the fact that he only calls him defendant? It doesn't give Trump any other title. At defendant's arraignment on April 4th, 2023, this court asked counsel for both parties to speak to your witnesses. Defense counsel, speak to your client. And remind them to please refrain from making statements that are likely to incite violence or civil unrest. Please refrain from making comments or engaging in conduct that has the potential to incite violence, create civil unrest, or jeopardize the safety or well-being of any individual. Please do not engage in words or conduct which would jeopardize the rule of law, particularly as it applies to these proceedings in this courtroom. The court then said to Mr. Trump, you have the right to be present at every stage of the proceedings, and that is obviously a very, very important right because it allows you to assist your attorneys in your defense. It allows them to consult with you. I think it's advantageous to have the jurors, if there is a jury, to see you present. So for all these reasons, I'm sure you can appreciate to be present at your trial and proceedings is important. I'm required by law to inform you that there are ways that you can waive your right, and I refer you to 2 specific areas. After the judge went through, do you understand your right to be present at your own trial? Defendant Mr. Trump said yes. And then the court said a second way you can lose your right to what you can lose your right if you become disruptive. If you become disruptive to such a degree that it affects my ability to preside over the case, I do have the authority to remove you from the courtroom and continue in your absence. Try you in abstention. Do you understand this, Defendant Mr. Trump? I do. That's from the arraignment transcript from April 4th of 2023. The judge is reciting that here for a reason, to remind Donald Trump that he's not going to put up with the shenanigans, the acting out, the violent attacks, and the disruptive behavior that he exhibited in the New York Attorney General civil fraud case, where he tried to give his own closing argument, where he continued to harangue and harass the judge. This judge has a jury to protect, has criminal justice to protect, and reminded Donald Trump, and Donald Trump acknowledged it. So when Donald Trump does act out, he's not going to testify. He's going to take the Fifth Amendment. But when he acts out in court, throws up his hands, rolls his eyes, tries to influence the jury, snickers, and if the judge doesn't want to hear it any longer, he's going to say, Mr. Trump, I warned you at your arraignment. You acknowledged my power, my ability to ban you from this courtroom for disruptive behavior. And if you interfere with my ability to preside over this trial in criminal justice, that's what he's going to do before he throws the book at him. He also went through in the transcript where he said to Todd Blanche, the lawyer for Donald Trump, he said on page 5 of the transcript, and did you explain to your client, he said, the court says now, did you explain to your client that this order constitutes a mandate of the court, this one about how he needs to act and perform and the limits on his statements made outside the courtroom? And he said, did you explain this to the court, Mr. Blanche? And Mr. Blanche said, the lawyer for Donald Trump, yes, he understands. He has to comply with the order. If he doesn't do, he's violating your honor's court order. And the judge went on to say, and a violation of a court mandate could result in sanctions. There are a wide range of sanctions. They could include up to a finding of contempt. You can explain that to your client. And Mr. Blanche said, understood, Your Honor. And so this is the ruling now of the judge in a decision and order. And this is not the last order we're going to see. There's still other motions concerning witnesses and evidence and arguments and witnesses and jurors yet to be made by Judge Merchan. We're watching a judge with full command after years on the bench and a sophisticated knowledge of how criminal courts work and the criminal justice system works, even when the other person on the other side of the V is Donald Trump. And we're going to follow everything that happens on the March 25th start of that trial. The pick of the jury. We'll have legal AF commentators such as my colleague and friend, Karen Friedman-Ignifilo, former member of the Manhattan DA's office. She was the number 2 lawyer in there to give us her insight, not so much her inside knowledge. She wasn't involved with this prosecution, but her insight. Only one place, MeidasTouch on Legal AF, every Wednesday and Saturday at 8 p.m. Eastern Time on this YouTube channel. And then on Hot Takes just like this one, where we do the intersection of law, politics, and justice like no other podcast. If you like lawyers talking about things where they know what they're talking about at the intersection of law, politics, and justice, it's one place, Legal AF. So until my next Hot Take, until my next Legal AF, leave a comment. Give me a thumbs up. It does help with the algorithmic gods and keeps us on the air. This is Michael Popok, Legal AF reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.